again. You can't begin to give in, it's all over when the snows come rolling through. You roll into with some new lover. Will you think of times you told me that you knew the reason why we had to each be lonely? It was just the season.
So hello everyone, good afternoon, and welcome to this session on promoting standards and the role of civil society and intergovernmental organizations. My name is Mariam Marzouki. I'm an academic researcher with the CNRS based in Paris, France, and it will be my pleasure to moderate this session. The objective of this panel actually is to discuss various soft law standards or soft law instruments and approaches that have been established to protect human rights online, and to discuss also the challenges to realize, concretely realize this human right. Now, why will we be talking about soft law? Actually, binding instruments such as international treaties, like at the global level, the International Covenant on Civil and Political Rights, for instance, or regional conventions on human rights, or even regional legislation, such as in the European Union, or national laws. All these are binding instruments, which means states, governments have to obey these instruments. Now, binding instruments like those don't necessarily specifically address the online world, especially in regions of the world and countries where the internet is not necessarily well developed yet. Moreover, we are talking about the online world, which is a very fast moving world, when we see every day new applications and services being developed and used by different kind of actors, and the law, the legislation, cannot necessarily evolve or follow the same rhythm. Moreover, the law should remain general enough to be adapted and interpreted by courts in different contexts, and cannot necessarily deal with all technical specificities. So soft law instruments are thus developed as guidelines for the interpretation of the law and to address evolving developments. Such soft law instruments may include declarations by a group of states, recommendations, resolutions, guidelines, best practices, etc. In the field of human rights, actually the first global instrument is of course, the United Nations Declaration of Human Rights, which is not directly legally binding for states, but inspired a set of legally binding instruments. Since we are at this Freedom Online conference, I would also like to mention the United Nations resolution adopted 1 year ago in July on the promotion, protection, and enjoyment of human rights on the internet. And this declaration reaffirms the Universal Declaration of Human Rights, and it also affirms that the same rights that people can enjoy offline should be also respected online. And that's very important development. Now, these soft law instruments are often proposed, discussed, and adopted at the initiative of intergovernmental organizations, either at a regional level, such as the Council of Europe for the European territory, or the OECD, the Organization for Economic Cooperation and Development for member countries, or at global level, but through the UN agencies which are dedicated and which specialize in a given field. Examples are UNESCO in the field of education, science, and culture, the ITU in the telecommunication field, WIPO for intellectual property, ILO for labor, etc. And in many cases, and more, intergovernmental organizations like those are very keen on working closely with NGOs and civil society group on such soft law instruments. They do this because civil society brings its own expertise and experience in a given field, especially in the online environment, but also because of democratic reasons such as inclusiveness and openness of civil society. Sometimes it's also a way to facilitate and even to put some pressure sometimes on national governments to adopt the resulting instruments. Our panel this afternoon will report and comment on such processes and collaborative efforts of NGOs and intergovernmental organizations to promote and defend human rights online. And we'll mention also, since we want to be concrete for the discussion, they will mention specific resulting soft law instruments that have been adopted. So we will discuss why it is important to operate at the regional or global level, how these efforts translate or sometimes don't translate into national laws, since after all it is at the national level that the legislation will be applied concretely. We will also address specific challenges in the Middle East and North Africa, and also in the African regions, especially since Tunisia belongs to both regions, but still always taking into account the universality of human rights. Now it is my pleasure to introduce our speakers. We will have 4 speakers today. We will have first Guy Berger, who is the Director for Freedom of Expression and Media Development at the UNESCO. We'll have James Lawson, who works with the Internet Governance Unit for the Council of Europe, this for the institution presentations. And then we will have Fike Jensen, who is with the Digital Defenders Partnership Program at HIVOS Foundation in the Netherlands. And last but not least, we will have Henriette Esterhuizen, who is the Executive Director of APC, the Association for Progressive Communications, and Henriette is based in South Africa. Now I will give the floor to our panelists. Guy, please.
Thank you very much, Miriam, and good afternoon to everybody. So I'd like to start with a big picture with some basic observations that I think the soft law is often counterposed to hard law, and understandably so, because if you have good soft law, you don't need hard law. And in fact, quite often it's very hard to get hard law made, and in fact you have to rely on soft law. And I think underpinning both of those is really the concept of norms, because without norms, you're not going to have soft law, and without norms, you're not going to really have an informed law. And in fact, norms are so important that if you want to interpret law anyway, you need some reference to norms. So I think the softest side of things is the norms, which is not to say they are easy, they're actually very hard. But to give you the example, to illustrate what I'm saying with UNESCO, so UNESCO has 195 member states, all of whom are supposed to support freedom of expression, because that is part of the constitution of UNESCO. So if you become a member, you sign up to that. And then us as the Secretariat in UNESCO, we have to say to member states, hey, the norm is freedom of expression, and any restriction should be the exception, the norm and exception. So that becomes the sort of soft law principle, I suppose. Maybe law is even too strong a word there. Now, when you come to talking about norms and soft law on the internet, it struck us at UNESCO that different people approach this question from different views. So, in fact, this very conference is called the Freedom Online Coalition, and people speak about the free internet. And other people approach the internet differently, and they speak about the open internet. And then some people say, well, let's talk about access, and then you get a dialogue completely across each other. As I've seen at some conferences, so some countries are talking about freedom and other countries are talking about access. And there's no common meeting of norms about these. So in UNESCO, we thought, if you want to get some norms that are going to be at a very high general level, you've got to get a comprehensive concept of the internet. And it's a bit like that famous story of the blind people touching an elephant, and the one touches the leg, and the other one touches the trunk, and the other one touches the tail, and they all describe it differently. So now you have 2.7 billion people touching this internet, okay, and they all have a very different experience of it. And some think it's a security issue, and some think it's a rights issue, and other people think it's an access issue, and other people think it's a business issue, and so on. And of course, it's all of these things because it's one internet, as fragmented and diversified as it is. It's one animal. So we tried to capture this idea of the internet as something that's for everybody and by everybody and of everybody under this phrase, internet universality, which sounds like a bit of jargon, but I think it's very important because it points you towards basic norms that make up the internet. The internet would not have got to where it is if it wasn't for these norms that underpin it. It would not be as universalizing where it's becoming so much part of life, even in countries where there's not a lot of access. And there are four elements that we identified. You could say the four legs of this elephant. And to use an easy acronym to understand these, you can use the English word ROAM, R-O-A-M. Okay? These are the four normative legs of the internet according to this concept of internet universality. So R is the rights-based, that the internet without rights won't be the internet, certainly won't be universal. You'll have a balkanized internet and so on. And then the R-O-A-M, so Rome. So R is for rights, O is for openness, because the internet has only developed as it has because there has been a norm for openness, which has been open technology, open sharing of information, Wikipedia, for example, open access for entrepreneurs, openness, you can keep on going. There's a lot of behavior and norms around openness. And then the third area is access, because, of course, without having access, you don't have an internet that's universalized. And access is, of course, technical, but it's also linguistic. It's access for people with disabilities, et cetera, et cetera. And the last one, the M, R-O-A-M, is multi-stakeholder. And of course, that's why the internet has become what it's become, because it's been a multi-stakeholder phenomenon in terms of its development, but also in terms of its governance. So R-O-A-M. Now I think to come back to this where I began, and then I'm finishing my point. Basically, you can begin to understand that if you want internet universality, you need all four of these legs. Because if you have the freedom without the access, well, you know, it's not universalized. If you have access without freedom, it's access to a very limited internet, etc. You know, so these are interdependent aspects of this internet animal. And you cut off one leg of the elephant, this elephant can't run, basically. It cannot roam. You need ROAM. You need the rights, you need the openness, you need the access, and you need the multi-stakeholderism. And I think what's important is that you need all of these. Okay, and within each of them, for example, now the big issue about the freedom thing that people are talking about is it's not just freedom of expression, it's also free. If you understand freedom, what does freedom mean? It's actually, the way we are interpreted is it's your rights. Okay, it's a freedom to access and use all your rights. So it's a freedom of expression, but it's also the freedom for security, to live a secure life. It's the right to reputation, right to dignity, etc., etc. So rights is, all your rights are put into that particular component. And then, of course, you've got to figure out, you know, which right is more important in any given situation, and public interest comes into question there. But I think unless you have this very big concept of what the internet is and how it's interdependent, and you recognize that these four elements depend on norms. In other words, there's a norm of openness, there's a norm of multi-stakeholders, and there's a norm of rights. And there are norms that access should be deepened. If you don't have that, how can you have soft law? Because soft law must build on these norms. And the more you can actually strengthen these norms through hard programs, the more, in fact, you can then create a foundation for soft law. And the soft law, in turn, if need be, can create a foundation for hard law. So those are my introductory comments. The ROAM, the elephant. Thank you.
Thank you very much, Guy. Thank you for this metaphor too that I like very much. I only hope that the internet will not be the elephant in the room. So now I will give the floor to James for his presentation, please.
Thank you. Good afternoon. I work for the Council of Europe. For those of you who may not be aware of that, it is not the European Union. The Council of Europe represents 47 member states and spreads across the whole European continent. The Council of Europe is a human rights organization. We work on the issues of human rights, democracy, and rule of law. And therefore, when we look at internet governance issues, internet freedoms issues, we look at these through the looking glass, so as not to say the prism of human rights. And we do that in basically 3 different ways. The Council of Europe is a standard-setting organization. We develop international treaties, international soft law, on issues related to human rights, democracy, and rule of law. We also develop, and that is one of our specialities, and we're very well known for that, is we also develop monitoring bodies that are there to ensure that these treaties are honored by the parties that sign up to them. A third aspect of our work, which is less talked about, is we conduct a lot of cooperation activities with member states to ensure that their national legislation and practice falls in line with the various different instruments that we have set up. So we establish, as an intergovernmental organization with 47 member states, binding treaties. Some of these you will of course know about. Those of you in the internet governance field will of course know about the Cybercrime Convention and Convention 108 on data protection and privacy. You'll also know, undoubtedly, about the European Convention of Human Rights, which was the first treaty that we established in the Convention, and which remains today, 60 years later, the base on which a lot of our work on the internet and freedom on the internet is developed. So to come to the soft law, in the Council of Europe we develop various different texts, declarations, recommendations, and even guidelines. And they come in a way to reinforce or to contextualize some of the major principles that have been developed in the European Convention of Human Rights and other treaty, but to bring them in line with what is happening in society today. I'd like to give you just 3 examples of the kind of texts that we develop. And the reason why these soft law texts are important. The first is that these texts are adopted by our Committee of Ministers, which is basically the Ministers of Foreign Affairs of the Member States. And these texts are adopted by consensus, generally. One of the advantages of soft law over hard law is that soft law doesn't have to go through the often lengthy, difficult procedures of having the convention implemented into the national law. This can take a number of years, and in fact, states are not obliged to ratify the conventions that we develop within the Council of Europe. Soft law, on the other hand, enters into force on the moment it is adopted by the Committee of Ministers. So there are a number of advantages in soft law. I'll talk about give you three short examples of relatively recent texts that we've adopted. We adopted a Declaration on Internet Governance Principles in 2011. And in there, we are an international, intergovernmental organization. The declaration looks at the responsibilities of states and emphasize that states have the rights and responsibilities with regard to internet-related issues, but they also have the duty to refrain from actions that would directly or indirectly harm persons or entities outside their territorial jurisdiction. That might be topical at the moment. Round about the same time as that, we adopted a recommendation to the member states and on the protection and promotion of the universality, integrity, and openness of the internet. And in there, one of the main principles is the principle of not doing any harm to the internet. And quite often people refer to this recommendation as the do no harm recommendation. And there again, it's emphasized the responsibilities that states comply with international human rights law and the principles of international law, and that their actions do not have an adverse impact across borders. More recently, and this some of you may not be aware of yet, but just last week, our Committee of Ministers adopted a declaration on risks to fundamental rights stemming from digital tracking and other surveillance technologies. That was adopted on the 11th of June. Now, unfortunately, the news at the time meant that we didn't get quite as much press coverage as we would have hoped. But maybe we will as the heat of the news cools down. And in that declaration, which again I stress was adopted by the 47 member states of the Council of Europe, in that declaration we say that member states have various obligations, including negative and positive obligations. They have an obligation to refrain from interference with fundamental rights, and they also have a positive obligation is to actively protect these rights, and that includes protecting individuals from action by non-state actors. Further in the declaration, the Committee of Ministers goes on to encourage our member states to bear the human rights risks in mind in their diplomatic efforts, and ask them, when necessary, to consider the introduction of suitable expert controls to prevent the misuse of technology to undermine those standards. Now, if ever there was a topical declaration, that was one, and that was just last week. So this is just to illustrate that these soft law instruments bring the fundamental principles into the context that we are dealing with on a daily basis. to give an illustration of what we're working on right now, at the moment we're working on a text on the rights of internet users. And there what we are trying to do is, as some people have said already in this room today, not develop new principles and new rights, because we feel very strongly that the existing rights have been well defined. But rather we are trying to bring the different rights as expressed in hard law and soft law together into a single instrument or text that can then be leveraged, first of all, by internet users themselves when interacting with their governments, but also when interacting with businesses. And that, I think, is an important aspect of soft law. Now, there's another aspect of soft law that we tend to ignore or forget, and that is that in our context in the Council of Europe, the European Court of Human Rights frequently refers to soft law in its judgments based on the European Convention on Human Rights. I give you one of the most recent examples that concern us is, if you know, the Yildirim judgment against Turkey, which was adopted just before Christmas. That refers to no less than 6 soft law instruments adopted by the Council of Europe. Now, I think one of the key working methods of the Council of Europe is to involve civil society as much as possible in its workings. And this has been going on since the creation of the Council of Europe. We have always had civil society actors involved in the work of the various committees that draft these instruments. And it's no different today when we're drafting instruments related to internet governance. What's perhaps slightly new in our field is that in addition to bringing civil society into the committees that draft these texts, we are also bringing business and the technical community on board when drafting the instruments that then go on to be adopted by the Committee of Ministers of the Council of Europe. So I think that's where I'll stop, just to stress the view that you need to have these various different actors on board very early in the drafting process of these texts if you want them to stand the test of time. And I think I'll just stop there for now.
Thank you very much, James. I can confirm, the openness of the Council of Europe, and this is exemplary process, I would say, because I am personally participating to this group of experts who are drafting and discussing these soft law instruments, and being there from the very beginning, the very first step. As civil society organization, we have a real voice that we can find in the final results when the soft law is adopted. Now I suggest that we hear from civil society, and first we will have Vicky Jensen from Hivers. Thank you.
Hi everybody. I sort of want to start off where Guy left off with the norms, but I think I will be giving a different perspective of things. I think the Freedom Online Coalition in Tunis is a great opportunity and a venue to start talking about the challenges that are posing sort of internet freedom and regulatory frameworks. Because I do think there's a lot of norms out there for internet freedom and protecting human rights within the system. But I do think that the PRISM scandal, from a Dutch point of view, couldn't have happened at a better point in time. And this is because I believe that the main fundamental challenges to society at large, but also to the soft principles, is translating international agreements and international soft principles to the national context. If you currently look at the US, but also if you look at the Dutch government, for instance, there's a lot of commitment to freedom of expression, freedom of information, internet freedom. But you see that that's a very progressive and liberal force behind internet freedom. In the national context, you see the debate is owned by the national security agencies, the army, and our Ministry of Safety and Justice in the Dutch case. And which means that the discussion is completely warped and there's a lot of friction in it. because every time we propose to talk about whether things could be legal or not, or to what extent somebody could interfere on your rights as a citizen, the national security issue is pulled in, and it will always trump any international soft law standards that is there. And I think it's actually the national laws that are currently being created on internet freedom are undermining a lot of the international human rights principles, the soft law standards, and actually, in fact, the sovereignty of states. Because we have a proposal that, a proposed legislation coming on, so we have the PRISM scandal, but we have a proposed legislation coming on where our Dutch Ministry of Safety and Justice and Security will be able to break into computers of citizens in other countries. And where does it leave another country if you can't protect your own citizens from other states? And I think any claim to internet freedom is seriously undermined there. And then I think the second challenge in these soft law standards conflicting with national legislation is that there's a lot of need for big data. There's a lot of need to surveil certain types of people. But our government is not equipped to do it. They will hire third-party entities to do it because they don't have the technical capacity. And this is where you get a whole new debate going on what happens as a citizen if the key functions of your government are done by third parties, which are usually commercial actors, and how does that then relate to human rights principles in the international arena? And how can you ensure that these third-party commercial actors will not misuse and abuse your personal data that they're collecting for national governments? And then I think the fundamental challenge also with creating soft law standards, but also creating national legislation, is do we actually need new laws and new regulatory frameworks for the internet? Can current regulatory frameworks not apply to certain things? I think it is always, our national legislation is being proposed that they need access to personal computers, both in the Netherlands and exterior to them, because otherwise they can't fight cybercrime. But you can still also trace money, and there's other things of fighting cybercrime. So how many freedoms are we willing to give up that could be also done in a different way under other legislative frameworks? And I think, speaking from working for an NGO, I think our role is to challenge both our national government and also the international coalitions that are there to challenge national governments to really move away from the cybersecurity domain that is dominating the discussion and talk on a more holistic approach. And I mean, I know it's not a black and white discussion and there's a lot of gray in there, but I think if we continue putting our internet freedom and human rights principles in the hands of the army and the national security agencies, we will fail anyway, no matter how many soft laws there are. And I think we have to approach it as it affects us all as an individual. It impacts the people everywhere, because if Western countries are spying on their own citizens and citizens in other countries, how can we then talk about other stuff other governments are doing? And it also deeply undermines the work that most of the people in this room are doing.
Thank you very much, Ricky. As civil society organization, we still have a long way to go, as I see. Our last but not least presentation will be by Henriette Stuyvesant from APC.
Thanks, Miriam. APC is an international network of civil society organizations established in 1990, so we've been around working on the use of ICTs for social justice. I'll talk briefly about our experience with soft law instruments, and then I think dwell maybe also on the risks, as Fika has done, and the advantages as well. Our first sort of soft law instrument was developed in 1999 when we were doing research on the state of the internet in Europe, Latin America, and Africa. And we realized we needed something to use as a checklist. So we developed the APC Internet Rights Charter, and we've since updated it. And then that led into another soft law process we were involved in, which is the Internet Governance Caucus Internet Rights and Principles Coalition, which was a multi-stakeholder forum which built a charter of principles that has focused very much on human rights and using the International Declaration as a starting point. And then we were also involved at a national level in something called the Brazilian Internet Steering Group Statement of Principles for Internet Governance, 10 Principles for Internet Governance, which our member in Brazil was very active in. And that also is in fact an example of how soft law can then move into hard law, because this statement of principles, which is developed by a multi-stakeholder group, formed the basis for a process of developing draft legislation, the Marco Civil, on the internet, which covers internet intermediary liability, data retention, and freedom of expression on the internet. We've also been, interestingly enough, involved in a more process-level soft law instrument, which was working with Council of Europe and the United Nations Economic Commission for Europe on something called the Code of Good Practice for access to information, public participation and transparency in internet governance. And this really focused just on how should policy-making processes be inclusive. And in fact, the Council of Europe drew on that work when they've developed some of their medium soft law going into hard law instruments. So I think what has been valuable about all of this, and I think we've probably dwelled on a lot of that, I think that the greatest value in soft law actually, I think, lies in the process of developing it. It localizes the issues and it localizes the concerns, and it's easier for people to participate. So if you're a techie or a hacker or a programmer, developing a set of principles that come from your particular angle and that speaks to your particular concerns is a much more interesting process than one that's being developed by human rights lawyers, for example. And you might home in on the same issues, but you'll talk a language that you can identify with. So there's more ownership. I think it also exposes differences if it's done well. And I think what soft law processes do is that they take the multi-stakeholder process from sort of courting and flirtation and endless dates to beginning to develop, you know, what would go into your prenuptial contract if you actually did something together. And I think so much of what we do in this multi-stakeholder universe of internet policy is very intangible. But I think if you are developing a set of principles or any kind of soft law instruments, it does expose differences in interest as well. And you have to talk through them. I think it also is bottom up. And I think anything that's bottom up, you know, has limitations, but it has value. And it can begin to change behavior. And I think we see that with many of the soft law instruments we've developed in this sector. That it can change cultures, it can contribute to building a culture, and I think building more common ground as well. So Guy was saying how open internet and internet freedom means different things to different people. That's absolutely true. But when we start trying to codify that and capturing the norms, it creates more of a common language and a common understanding. And then I think it's really important as a monitoring tool and an advocacy tool. For example, on the 7th of June, a group of civil society organizations published the International Principles on the Application of Human Rights to Communication Surveillance. Now, the timing could not have been better. So, you know, if anybody now wants to start evaluating what their country is doing, there's a set of principles that they can refer to. So it's a really good monitoring and advocacy tool. I think just to dwell maybe on some of the challenges. I think when I wrote them down, they all ended up starting with C, which is completely, you know, coincidental. Confusion, I think. I think that having so many different codes of practice, statements of principles, can be quite confusing, especially for newcomers into a field. I think context, that's the second C. And I think, you know, James's comments really illustrate that. If you have, as in Europe, good regulation on data retention, then internet intermediary liability means something different. Surveillance means something different. The effect is very different. So, this is all an ecosystem. So a statement of principles that might sound really good in one country could actually be very meaningless in another country because some of the basic building blocks of rule of law and due process are just not in place. And then I think compliance and capture, and I think they work together. I think an advantage of soft law in which business and governments and civil society are involved in is that, generally, if you're involved in developing a set of rules or behavioral norms, you're more likely to comply. So that is an advantage. But then the counter challenge to that is capture. It's very easy then for in this multi-stakeholder process, the companies, or the governments for that matter, that are involved in developing these norms to capture the outcome so that they can in fact comply and that it doesn't really challenge their existing practices. And then I think the next challenge is that it becomes circular. And I think you've all touched on that. At some point, these soft law processes do need to break out of the soft law loop. And you do want to start actually identifying where does rule of law, where does due process need to be strengthened? How do you strengthen it? Does it need capacity building? Can it work on a regional level? But at some point you do have to break out of it to really concretize the protections that you are after. And then I think, just finally, I think the risk is, and I don't have to say much about that because I think Ficker did, and that is it doesn't start with a C, that's the parallel universe. That we've been here, we've been talking about internet principles, internet rights for the last 8-10 years. And we've just had this exposure about surveillance, and the companies that are involved, the people that are involved, I'm not sure if G&I representatives from those companies were even aware of what other people in their companies were having to address in terms of requests from governments. So I think it's so easy for us to live in this universe where we talk about all the good things we believe about the internet, when in fact there are very different things happening elsewhere. So I think that's also another challenge to make sure that those links across the two universes of what really happens and what we would like to happen are made.
Thank you. Thank you very much, Henriette. Thank you for being so concrete. Now we will open the floor for questions, comments, experience that you can share. I don't know if we have someone from GNI. I cannot see anything at this because of the... Are there any questions? Sorry. Yeah.
Yes. Thanks for this presentation. So my name is Rafik Damak. I want really to ask Henriette, because you talked about that we have many internet rights principles, declaration. It's confusing. It's a long list. But my question is how civil society should try to work to coordinate better, to avoid overlapping, and so we can focus on the promotion and to try to convince government, private sector to embrace those principles. So how we can improve that work and to avoid to reinvent the wheel every time. I understand also that the Council of Europe is working in the compendium. Maybe Mariam or the representative from Council of Europe can describe that work too. Okay, thanks.
Merci beaucoup. Moi, je voudrais juste poser une question à monsieur le représentant du Conseil de l'Europe. Internet a atteint sa vitesse de croisière, mais nous constatons un retard considérable, un écart entre l'Europe et l'Afrique. Aujourd'hui, vu les différents thèmes qui sont abordés ici, je voudrais vous demander si vous avez prévu dans votre programme un axe de coopération multilatérale entre la Commission africaine pour aussi permettre à ce peuple africain qui est à un niveau un peu moyen par rapport à Internet, donc de pouvoir obtenir des droits élargis pour quand même être au même niveau que le reste du monde. L'autre appréciation, c'est ce que vient juste de dire le premier intervenant. La société civile actuellement qui joue un rôle considérable donc à travers différents programmes de développement, je pense aussi néglige un peu ce volet africain. Nous n'avons pas constaté tellement donc un encadrement ou bien un support intellectuel par rapport aux différentes organisations dans différents pays africains. Donc le troisième point, donc, c'est aussi, je reviens sur le cadre juridique. Et donc de voir si au niveau des Nations Unies, vous avez quand même des prérogatives d'introduire quand même des lois qui seront universalisées et donc qui protégeront un peu quand même ces différents mouvements qui sont souvent censurés par rapport à des arguments ou des idées quand même politiques qui n'arrangent pas nos gouvernants africains. Je vous remercie beaucoup.
Any other question, maybe a third question or comment? Yeah, there is one. I can't see. Je peux pas du tout y quelqu'un. Yeah.
Hi, so I'm curious about one thing, which is when we look at corporations like Facebook or Google and we see their denials about things like PRISM, how is it that we're supposed to trust them when the law literally, in some cases, says that it is a crime for them to reveal what they know? And yet at the same time, we, for example, take their statements as fact. It seems like we need to recognize that, at least in the United States, when you will be criminally sanctioned for speaking out about these things, or perhaps you are not cleared and read into the programs, that is to say you're not legally allowed to be told by your own staff that it's happening. On the one hand, we need to say, how can we hold these corporations accountable for living under a government that is taking a tyrannical action, even though it is an otherwise potentially not tyrannical government? On the other hand, shouldn't we be taking these companies to task for being agents of the state in secret? Shouldn't we be asking them to cry out about this, asking them to reveal this data? And how is it that we can actually trust them if we are to maintain this tenuous balance, I wonder? And is it possible that the EU can force legislation that says if a company does not disclose these things, that they have committed a crime in the European Union, so that those corporations will have to make a choice in such a way that being bound by that law will require them to either not do business in the EU or not do business in the place that forces them to do that? And what action should I take as a private citizen that is not a European Union citizen, I might add, to help make this happen? That's a lot of questions, but I think you guys can really tackle that.
Thank you. I think we will have a first round of answers by our panelists, and then we will get back to the audience. So who would want to take up any of the questions? Maybe the Council of Europe was directly mentioned.
We were directly mentioned. Our colleague from Africa, somewhere, talked about whether we're turning our eyes towards the African continent. Directly, no. I mean, the fact of the matter today is that the Council of Europe has difficulty coping with its own 47 member states. This being said, the Council of Europe is very much committed to the idea of universality of human rights. And what we do know is that the case law of the European Court of Human Rights is leveraged by various different regional bodies and national bodies when developing their own case law. So indirectly, we do have an effect throughout the world, in fact. More concretely, one of the for Tunisia in particular, the Council of Europe is involved with a number of cooperation activities with Tunisia. One of the priorities we have right now is to consolidate our space, and that means consolidating democracy, human rights, rule of law in our space means working with our neighborhood, and this is the Mediterranean neighborhood. So we are developing contacts with the states on the Mediterranean fringe. We recently opened an office in Tunisia, and one of the first things we did was to organize an exchange with the Arab Institute of Human Rights here in Tunisia and La Francophonie on freedom of expression. And in that, there are discussions around freedom of expression, of course, on the internet. So yes, we do, but with limited means and within that geographical space. Another thing we're working on is working on cyberspace as being one of the spaces where we have to develop our European notions of human rights, democracy, and rule of law. And that is why I'm here, and that's why I work in the Internet Governance Unit. So indirectly, I would say yes. Directly, no. I cannot speak on behalf of the European Union. No, and I won't, and I won't. What I can say is things are never easy, and if things were easy, we wouldn't be here, and if things were easy, we wouldn't still be discussing human rights issues more than 60 years after the Universal Declaration. This is an ongoing battle that we have to face. Now, one of the interesting developments in Europe is that the European Union as an institution is committed to signing up to the European Convention on Human Rights. Now that has has many very interesting repercussions, and that means that any of the actions taken by the Commission as a body must comply with the human rights standards set by the European Convention of Human Rights and will be monitored through the European Court of Human Rights. So law takes time. I think that's one of the difficulties we have, is that technology moves very fast. Law doesn't move so fast. The question there, of course, is whether the principles are changing or whether it's just the context and the individual manifestations of violations of human rights that are changing. I'm convinced that the convention, as written 60 years ago, is as valid today as it was then. So I think there are positive signs there that we have to look at. And there was a speaker that wanted to know more about the compendium. I could do that, and there are people in the room who could probably speak more about it than me, but I don't want to monopolize the microphone. But we can come back to that if you agree.
Thank you. I'll start with the last question because it's the most pertinent one for this time. I think that you are kind of between a rock and a hard place, because what you really want to do in an ideal environment is make your government hold those companies accountable for protecting your fundamental human rights. When your government is putting pressure on those companies to violate those rights and to not expose it, I think there's obviously a problem, and I think various problems, and I think it certainly means, I think in our case now, the pragmatic response would be really to look at not at the what is happening as much as the how it's happening, and I think multiple strategies, and I think probably this instance is one where you need a combination of using existing soft law instruments, testing whether they are being complied to, doing research and analysis, understanding why they're not working, if they are working, and then putting pressure both on those companies to comply and on states to be transparent about what procedures are. I think the risk for all of us as human rights activists is to elevate the big internet companies as our primary upholders and protectors of rights. It's very important to put pressure on them to uphold rights. I'm not saying we shouldn't do that. That's extremely important as consumers and also as citizens. But they also need to ultimately be accountable and states have the responsibility to uphold our human rights, and therefore they should be holding companies accountable. And if that's not working out, there's definitely something wrong that we need to challenge. But I think there are people in the audience who can say more about that. I think in response to Rafiq's question about confusion, and maybe to some extent that can also respond to your question, how do we avoid reinventing the wheel and also, just localizing things? I think that maybe these processes are cyclical to some extent. I think we've been through a cycle of developing a lot of soft law principles and exploring principles. Maybe we should now be going into a cycle of really going more vertical. So in Africa, for example, we have the African Commission on Peoples and Human Rights, which is a formal body. There's a charter, there's an African Charter on Peoples and Human Rights, which is a very strong charter. It has very good content. So I think what we really should be doing is working on those instruments, strengthening them, working with the rapporteurs on freedom of expression. And at the moment, one of the weaknesses in Africa is that once complaints, human rights violation complaints that go to the African Commission on Human Rights, goes to the African Union, they are often not taken seriously by governments because, as you say, they don't always take free speech that seriously. So we need to work at that level as well. I think similarly, Rafiq, I think maybe also to go from the general to the specific. So we've got good ideas of what principles we want as far as freedom of expression and freedom of association on the internet. Now we need to look at what do we want data retention regulation to look like? What do we want protection for intermediaries from being held liable to look like? What do we mean by openness, open standards, open protocols? How do we, so I think, and maybe it's a dialectical kind of process, we go from the general principles to the nuts and bolts to the general. But I think we definitely, at this point in time, should be focusing very much on the nuts and bolts of what it is that is preventing our rights from being protected.
Vicky or Guy, do you want to add something on?
Yes, I would like to respond to the last question. And I think I'll respond as a European citizen, because I think, should the EU do something? Yes. Will they? That's a big question mark. If I see, for instance, after the PRISM story broke, the reaction of the Dutch government was, our Prime Minister was at a Google Tent event. He was a little bit angry about what happened with the PRISM, and he thought it was not okay. And apparently he was quite vocal about it. At the same time, there was our Congress was asking questions to our Ministry of Safety and Justice, and it was live streamed on TV. And he was actually defending the PRISM story. So I think in looking at national governments or EU bodies to sort of hold Facebook or Google accountable for what they're doing with our personal data, I think the governments themselves are too fragmented on this issue that they will probably not act about it. Because for, I think, our minister, he was defending it because he's also defending his own piece of legislation. And if like a national government's already so divided on the issue, the EU will be even more divided on the issue. And I think one of the major problems within the European Union and within our national context is actually that the governments can get away with this fragmentation on personal data because people have the feeling they have nothing to hide, which is just completely ridiculous. But every time this story breaks the news, they go, yeah, I have nothing to hide, and they continue doing what they're doing. So there's no pressure on our Prime Minister or the EU to actually do something about it.
Guy, do you want to add something at this point, or maybe?
Well, maybe in response to what some of my fellow panelists said and some of the points coming out from the floor. I think the thing is to try to underline the universal consensus possibilities and then to work from there, so that there are already accepted universal principles which, because they're accepted, they become standards. And then, of course, the thing is then to evaluate the models, and the models are mainly at law at the national level. And do the models fall within or without the norms, that some things are exceptions and some things are norms? And so I think much as there will be differences, much as there is fragmentation, we've got to hang on to that universality thing at a broad level and use that as the standard to try to evaluate how these things work. And that's exactly, I think, because of the the variations of national law and the fact that a lot of this stuff is transnational, it underlines even more how important the normative level is. Because a lot of the stuff, I mean, as was said, you know, how many countries can pass laws that affect how global intermediary companies are going to act in their country? Very few. And that's where the norms become so important, that the companies themselves feel bound by these norms at the global level. And it costs money to respect these norms, and they put some money aside for that.
Thank you. Also on the issue of having the companies acting or being forced to act as agents of the state, and this is the real way we should call them. It's very much linked to the development of big data, because these commercial companies, not only the American companies, all the IT online services companies, their economic model is based on this big data, how they can mine this data and obtain information. And what is happening is that in some parts of the world, like in the European Union, we have quite good legislation on data protection, and it is being revised, modernized right now. But what we see is that governments, and not only the US governments, the US government, also the EU governments and everywhere in the world, they are also aware that this big data exists, and that it's a huge amount of information for intelligence purposes. So first of all, maybe they complain about this, like what happens very recently with PRISM, but after a while, the reaction is to say, oh, we in the European Union, we also want our share of this data, and some have got already their share, like the Netherlands and the UK. This happened already with the passenger name record, for instance, with your dossier, your traveling dossier with companies, airlines, and this data are being used for intelligence before you land in the country, or before you even leave your country. It has also been, the commercial data has also been used for law enforcement and intelligence purposes, just like the communication and traffic data with all the data retention laws. So yeah, the European Union can do something and will do something, but I'm really afraid after some time they will want their share of data too. Yeah, maybe we have time to get another round of questions. You, Rebecca? Yeah, I cannot see.
I have a follow-up, which is that I think you're totally right about the big data thing, and I think that there are two serious realities we need to confront. The first serious reality that I think that we need to confront is a little difficult to swallow, but the basic issue is that the intelligence agencies are putting forth a vanguard surveillance and security strategy where they will keep us safe by watching everything. And the trade-off is that for the FBI or AIVD or these other intelligence agencies to be able to wiretap me, I get to wiretap you. That's a big part of it, right? So if you run a big company in Europe and you travel abroad, like let's say the Airbus CEO wants to bid against Boeing, how can they do this securely? Every phone they call is wiretappable, everything they do on the internet is basically wiretappable, and in fact we see that the NSA has given data to Boeing by the State Department, from my understanding, and that has helped them to basically win against Airbus. So I think we need to look at the economic realities of this and see that those trade-offs are not being discussed at all. And the idea here is that these spies need to keep us vulnerable so they can spy on us and spy on other people. And this is extremely dangerous in my mind. And then secondarily, this big data thing is not new. There's a company in Germany, it's called Deutsche Homag. They were the punch card company that helped the Nazis to eradicate the Jewry, the communists, the homosexuals, the Catholics of Europe. And in Holland, 70% of the Jews were wiped out because of Deutsche Homag's punch card machines. In France, it was only 30% because the punch card statistical system was run by a member of the French resistance, who died in a death camp, by the way. But Bull, one of the competitors of Deutsche Homag, and this was mentioned earlier today, actually has ties to AIMSIS, the company that is now building the popcorn system to surveil Morocco. So we see companies with political and economic ties to the Holocaust operating freely out of Europe now to oppress the people in this room. And they even sold the same, similar, or even the same systems to Gaddafi in order to watch people in Libya. And this was revealed by WikiLeaks in the spy files that they used that on people in France and the United Kingdom to target people. So we need to look at big data not as a new thing, but as an old lesson we are forgetting. And to see that this trade-off there is actually not being talked about in economic terms. And as a Jew who spends a lot of time in Europe, I tell you, I'm fucking terrified.
I am too. Thank you. Maybe one or two questions and we will wrap up. Yes, Rebecca, are there any other questions?
Hi, thanks. I totally agree with Henriette that it should be the government's primary responsibility to hold companies accountable to human rights, but as the PRISM issue shows and so many other examples cited, many governments are doing exactly the opposite, passing laws that enable their abuse of power via corporate platforms and entities. So at that point, then the question is, okay, so companies are facing laws and government practices that are preventing the companies from, I'm not so much talking about some of these, one could perhaps say truly evil intended companies that Jake cites, but let's assume you have a company that actually wants to uphold its human rights responsibilities. We have some obstacles being posed by governments. And what's been interesting, I think, that we've seen over the last couple of years is that there have been times when companies have seen it in their commercial interests to actually put major resources behind lobbying for a change of stupid laws or blockage of stupid laws that would result in greater violations. So the Stop Online Piracy Act was one such where companies saw it actually in their interest to stand on the side of users. The opposition to ACTA, the Anti-Counterfeiting Trade Act, which got blocked by Europe as a result of a movement that a lot of companies were very much behind. And then, of course, the actions at the ITU in Dubai at the end of last year, where companies actually saw it in their interest to, in their commercial self-interested for reasons to stand with internet users and civil society. And so I don't know if we have any company people in the room, because I think they may be all in the other session with Facebook, from what I can tell from the tweets coming off the stream. But I'm just sort of puzzled, given that some of these laws that we're facing, particularly in the United States right now, are a major barrier, it seems, now that they've been exposed, to users trusting these companies, and potentially a major barrier to their commercial success in the future. And I would really like to see these companies put some resources comparable to the resources they put behind fighting some other laws, to getting the Patriot Act reformed, to getting other laws reformed that would protect their users. But of course, this is hard. I mean, we've seen the lobbying that's gone on in Europe, and so I just wonder, given this, and sorry I'm going on so long, but sort of given that there are times when companies can be seen to understand or do have their interests aligned with civil society and users, how do we kind of move more companies on more issues, including more on privacy issues, to see that their long-term interests are actually need to be more aligned with the rights of their users, and to get them to really act and to advocate on policy. And to, unfortunately in many democracies where votes are for sale in parliaments, put some resources behind this. I'd be interested to hear people's
Thank you.
thoughts on that.
Thank you, Rebecca. I've been told that we have to wrap up, so what we will do is have some concluding remarks from all the panelists, and also may I remind you that we are asked for some recommendations or a quick recommendation or action line, and then you can take Rebecca's questions in the meantime. Maybe we start in the same order, please.
Well, understandably, a lot of the discussion has been about soft law concerning rights. But I'd say to people, please remember the total elephant, because there also needs to be soft law concerning all these other questions, because they are interdependent. So, if you're talking many parts of the world, access and what are the norms, and can you even have some soft law around access issues? And how does that relate to openness, and how does that relate to the different freedoms and rights-based issues? And it has been pointed out already that soft law practices around multi-stakeholderism should move to harder forms of law. But you can have soft law without that. And but I think if you try and have an integrated concept, you need to cover the waterfront. That's all I'm saying. Yeah.
James, please.
Yeah, I think with regard to business, I think one of the things that we in the standard setting world have to do is we have to be able to find new ways of working with different stakeholders. We have to find ways of working with business in the same way as we have a long history of working with NGOs when developing our standards. And that's not something that comes easy to intergovernmental organizations, certainly. I think there's also an issue of complexity here that we sometimes overlook, and it's been touched upon a little bit here, is that some of these large, very large corporations are complex businesses, just in the same way as governments are complex institutions. Not one ministry doesn't necessarily know precisely what another ministry is saying. Otherwise, we wouldn't have situations where you have a government saying one thing in the ITU and something very different in the Council of Europe. And it looks like it may be the same in the corporate world. So we have to find ways of discussing these things. I think from an intergovernmental organization's point of view, I think we have to emphasize the responsibility of states. And the states have the responsibility to protect the human rights of their citizens. And if that means interfering with the way that businesses go about their activities, then they should be doing that, even if it's complex. I mean, in Europe, and certainly the country that I come from, the UK, we have been tackling the issue of terrorism for years, dozens of years. But the UK government, when taking actions, when fighting terrorism within its own territory, for example, it has been held accountable before the European Court of Human Rights on the way in which it operates. And even in the fight against terrorism, human rights law applies, and the processes that the governments engage in must be transparent, must be accountable, must go through the kind of democratic oversight through parliaments, independent commissions, etc., that we expect. So, yeah, I think I'll stop on that.
Vicky?
I think also translating some of these issues is really important. So I think that's where I'll be going. I think for a lot of governments, but also for a lot of citizens, as soon as you mention the word internet or technology, big data, spying on citizens, cyber, anything with cyber, it sort of goes over their heads. Like they either stop listening or they think, oh yeah, it's really important that we protect ourselves from A, B, or C. But I think once you translate it into something very tangible, it can actually make an impact. So if you're discussing law or soft law, the discussion really goes into we need to protect ourselves to some sort of standard, so it's okay. But when you actually tell them what it is that a government could do or a company could do to spy on you, so they can't only read your email, but they can also turn on your webcam, they go, oh no, but that crosses the line, that goes too far. And I think to make it sort of more approachable for a lot of people, I think this translating it into anecdotes or examples is really important, because in the end, if you want to have a multi-stakeholder approach, and especially with soft legislation, I think you want to include also people who are not specialized in internet freedom related issues, and that means making it accessible to other types of people.
Thanks, Miriam. I think in terms of recommendations, I think we need to start at home. I think understand your national legal environment as far as data protection, data retention, internet intermediary liability, protection of privacy, freedom of information, all the legislation that impact on how we use the internet. So I think really understanding that is very important. And then linked to that, I think national norm developing processes, national multi-stakeholder norm developing process, such as the Brazilian Internet Steering Group, at a global level, the Internet Governance Forum, and so on. I think those are really important. And then I think to respond to Rebecca's question, I think, yes, we can do it. I think we can hold those companies accountable for resisting, for protecting user interests. I think it's tricky though, because I think data mining has reached a point of no return. It underpins innovation on the internet. It underpins improving user services. And so both for commercial, technical development and innovation, as well as crime fighting and security, intelligence and repression, state repression purposes, I don't think we can go back. So I do think that a pragmatic response, which is to put pressure on states and on companies for more transparency, for better process, for remedy and recourse when rights are violated, is actually really critical. And I think it can be done. I don't think it'll be easy. I think what's important, though, is to have a bottom line. And I think that's where James's points and Guy's point about the fundamental rights are still there. We should still go into those pragmatic negotiations with that bottom line in mind.
How's that actually working? How's that actually working out for you with the NSA right now? I mean, it seems to me that you might want to hear about a thing called encryption. And it seems to me that end-to-end anonymized, encrypted communications where we have authenticity, confidentiality, and integrity are possible, such that widespread data mining of traffic that is sniffed off the wire is done with. It's not that we can't go back. We absolutely can protect ourselves so that someone can't do that without due process. And in fact, when we add a backdoor to the system for legal purposes, the thing you have to recognize is that it will not be you and your courts that will be the arbiter of what happens. It will be mathematics and only mathematics.
Okay, thank you.
I think that's part of the suite of protections we have. Anonymity, encryption. You know, those things have to be legal, and they have to be legal everywhere and available.
I think you will have plenty of time for discussion. We have to wrap up. One quick word in conclusion. We have discussed how soft law instruments and even binding laws are necessary and should and are useful to promote and defend human rights. But in the end, eventually, any text, the best text, should pass the reality check. And it happens too often that we have very good legislation adopted, but in reality, human rights are still violated. We are in Tunisia today. This conference is wonderful. I'm Tunisian myself, so I cannot finish and conclude this session without saying at least a word on three young people in their 20s, only their 20s. One of them is a young girl she's 19 years old, not even in her 20s. The three of them are in jail for having exercised their human right, freedom of expression, freedom of artistic creation, and freedom of thought and conscience. Let me just say their name, at least. Maybe the message can be conveyed. Jabir Mejri has published on Facebook, online, texts and caricatures of the Prophet Muhammad. He is in jail for 7 years. His friend, Razi Beji, has just obtained, for the same issue, has just obtained political asylum in France. But he also has been sentenced 7 years jail. Amina Sboui, you probably have heard of Amina. She is in jail waiting for the alleged charges being investigated. Among these alleged charges, there is that she belongs to a criminal organization. She could be sentenced for up to 6 years jail. She has published, at the very beginning of the story, she has published photograph on her Facebook page, topless, with, the feminine slogans. It was a political message, like it or not. Whether we like it, this modus operandi of the feminine doesn't matter. This was a political message, and she risks a lot for this because it was the beginning of the story. And very recently, a singer, a rapper, has been sentenced 2 years jail for having exercised his freedom of creation. What is artistic creation for if it's not to express provocative thought and have the society, all the people to think about this and to follow or not? But at least this doesn't deserve prison, years of jail. And this is, a lot of people are very concerned about this situation. I'm sorry to end with this bad news, but I really wanted to convey this message. I was the co-chair of the Human Rights Civil Society caucus during the WISIS, the World Summit on Information Society. We also had a hard time, including in Tunisia, but we have to do this, I think. So thank you for listening to that, and please join me in thanking our panelists, and I would like to thank the audience for its participation too. Thank you.
If I were a painter, I've tried so hard, my dear, to show that you're my every dream. Yet you're afraid each thing I do is just some evil scheme. A memory from your lonesome past keeps us so far apart. Why can't I free your doubtful mind and melt your cold, cold heart? Another love before my time made your heart sad and blue. And so my heart is paying now I didn't do. In anger, unkind words I said that make the teardrops start. Why can't I free your doubtful mind and melt your cold, cold